Hello, good morning. This is Mr. Laporte, and I just want to get back to what we're talking about on Tuesday, the Fifth Amendment. The thing that they talk about on most crime shows, right to remain silent. And we looked at cases from Miranda versus Arizona and um, the Miranda rights that we have today from that case. Not a great person, but his what he went through, um, even though he wasn't that great of a person, helps us today. If we are arrested, then you have Brown versus Mississippi. The three gentlemen there beaten until they confessed. Not a great thing to happen there, but we benefit from that today. That really not. In the movies, maybe they interrogate and rough some people up, but not a wise thing to do for the police if they want a case to stick. Um, Article that I had you guys look at also went over action with Juan Rivera, and he was found guilty, retried a second time, and then finally got another retrial. And even though the DNA was not a match from him pointed to someone else, he still was convicted again. And I just don't know how a jury could be given DNA evidence. Wasn't there, but you're wondering how they could be given DNA evidence that shows he's not the perpetrator of the crime and then still have a conviction. All right. So that eventually was tossed out and he was let go because he's not given his rights of due process. All right, so um, the case that we're looking at today is the Sixth Amendment, and I'm going to try to look at what it actually says. What does the Sixth Amendment say? In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. You have the right to a lawyer, and you have the right to a trial in the district where the crime happened. Uh, Impartial jury would be people that do not have anything against you. I was two times I was on a jury, and one of the questions they asked us, they asked if anybody had DUIs or issues with the law, previous arrests for alcohol or something, and some people raised their hand and they were dismissed to go. Uh, when one of the questions I answered positive to was, "Is anybody here a veteran of the armed forces?" And I raised my hand, and initially, because I wanted to make money substituting as a young teacher, I was hoping to get out so I could make more money. They would give you $45 back then, and subbing was $85 to $100. So I raised my hand. I'm a veteran, and they said, "Okay, stay." And then after I thought about it, realized that people that were willing to risk their lives and possibly get shot at in wartime for rights, uh, probably the people that you want to have on the jury. So there was a couple of us, maybe three, four, perhaps, that had been in the military and ended up on the jury. So it was way better to actually be on the jury than being dismissed and to go home. That would have been a mistake on my part. So, Sixth Amendment. You also, if you commit a crime in Eau Claire County, you should have your trial here, unless there are special circumstances. If people here have issue against you and are going to possibly rule against you because they know you and maybe you have a reputation as a very bad person or something, and your lawyer would be like, "Oh, everybody in this community is against my client, so please let's take it somewhere else." Um, you will have the nature and cause of the accusation. So, like habeas corpus, you have to have an indictment. What are the charges? And before the trial, you have to be very specific. What is the evidence? What are the charges? Um, so that you can prepare the case, you and your lawyer. And you do have the right to defend yourself unless you are not mentally competent. The article that we read for today also talked about people that do confess to crimes that possibly are mentally ill or a mental defect. And what if you have a friend that you and a friend were accused of something, and a relative friend or whatever, and they're just not right, um, uh, and like to get attention or something like that? There's all different things that could happen, and they decide, well, I'm going to confess because they want me to, and then they won't go looking for somebody else. And I think it was this person, so I'm going to help them out. So I'm going to say that I did it. Just all kinds of reasons that some people confess. So if you look at the article there, it talks about a ton of the percentages of people that have a mental defect that are confessing to crimes that they didn't commit, and then they name you as a co-conspirator in some kind of crime. Not a fun situation. All right, so then you also have Sixth Amendment, the right to uh, having witnesses in your favor. I usually give out an assignment where it talks about somebody doing drugs at a party with some friends, and then that person gets accused of a crime, say murder, and uh, when they go to trial, the guy's friends don't want to admit that they were at a party doing drugs. So they're like, no way, I'm not going to go to court and confess to that because then I'll be arrested. So, in that situation, because the murder being a higher crime, uh, those guys were told if you go and tell your story, be honest and truthful about what happened, then we will not charge you for the actions you did at the party. More important to say what happened so that your friend doesn't end up getting charged for murder that didn't commit because obviously he was with you at that party doing things he shouldn't be doing as well. So uh, the law says we need to get witnesses in your favor, and then if you have witnesses uh, testifying against you, then you have the right to cross-examine them, and then you have the right of counsel. All right, so uh, Sixth Amendment, um, or this would be Fifth Amendment, double jeopardy. That if you're tried once, that you will not be tried again. There's a person in Maryland that was tried for two crimes. He was found not guilty of one and guilty of the other, and then it got sent back down to lower court, and they tried him again for both crimes, and then he was found guilty of both crimes. So double jeopardy. He shouldn't have been tried again for the one crime that he had already been found not guilty of. All right. And then hopefully, if you were here with us on Tuesday, you can think about how, what would happen if you're taken somewhere by the police and beaten until you confess. Um, Not a pleasant situation that anybody should be subjected to. All right, so um, today was Sixth Amendment. Gideon versus Wainwright is the um, court case that we look at. He was Gideon is the person, and there's a good movie with Henry Fonda uh, called Gideon and Wainwright. The defense was tried and convicted of breaking and entering a pool room with intent to commit a misdemeanor. Breaking and entering was a felony, more serious crime under Florida law. He asked for an attorney, but was told the judge he could only appoint those in capital cases, which are felonies. The defendant was tried, convicted, and sentenced to 5 years. He got some. The pool hall was lost $30 in change, so he ends up 5 years. The defendant filed a petition for writ of habeas corpus, um, and the Supreme Court of Florida denied his claim. So then it went to the Supreme Court. And if you watch the movie, when he gets to prison, he starts lawyering up himself, learning the law, studying, kind of becoming a lawyer, smart as a lawyer in jail, taking good use of his time in jail. So then he took his case to the Supreme Court. The Supreme Court held that under 6th and 14th Amendment, the defendant had a right to an attorney. Today, a person who can be jailed for any length of time has a right to an attorney. And this rule was announced by the Supreme Court in a case called Aslinger versus Hamlin. All right, so I was kind of shocked, even though I know a little bit about law and precedent and history, that this person in Florida, because for the petty crimes under Florida law, you don't get a lawyer automatically because it's an expense for the state. So thinking nationwide this is happening, but in Florida, if it was a misdemeanor, you're not getting a lawyer. Now, if you're just going to get fined and there's no jail time, then you would not be given a lawyer. So anytime you are going to end up in jail possibly for an action or crime, then you will definitely, if you can't afford a lawyer, one will be provided for you. All right, trying to stop this thing. Have a great day. Bye.